Last year, USCIS denied over 60,000 green card applications between family and employment cases combined. And if your Form I-485 just got denied, you have exactly 30 days, 33 if it was mailed to you, before your only listed options become a legal motion, a fight in court, or leaving the country. So go read the last page of that denial notice again right now, because that clock started the moment they signed the decision, not the moment you opened the envelope. I want to walk you through this today because it's one of the most common questions I get after someone has handled their own I-485. Why did it actually get denied? And I'm not saying that filing on your own increases your odds of denial. That's a separate conversation for another video. But imagine this. Someone files their own green card application, it gets denied, and now they're sitting across from me asking what their options are. And here's the honest truth. Most of the time, I don't recommend filing Form I-290B to reopen or reconsider a case. It's often not the right tool, but sometimes it's exactly the right move. And I'm going to show you two real scenarios so you can tell the difference. Because I am actually filing a motion to reopen for a client this week, and I think this is the perfect moment to break down how this decision actually gets made. Before we get into the scenarios, you need to understand something that has changed the entire calculation for anyone facing an I-485 denial in 2026. In May of this year, USCIS issued Policy Memorandum PM-602-0199, and it fundamentally reshaped how adjustment of status cases are decided. The agency has started treating adjustment of status, meaning getting your green card from inside the US, instead of leaving for a consular interview abroad, as what they're calling extraordinary relief, not the normal path. Officers are now told to weigh a much wider set of discretionary factors, including whether you let an underlying visa status lapse and are only surviving on a work permit tied to your pending case. And if that describes you, especially with any arrest history in the mix, your file is now sitting in a higher risk category than it would have been even a year ago. Here's the part that makes this urgent instead of just interesting. Under a separate framework that has been active since 2018, USCIS can issue a Notice to Appear, the document that starts removal proceedings in immigration court, as soon as your I-485 is denied and you have no other lawful status to fall back on. Combine that older NTA policy with this year's tougher discretionary standard, and a straightforward green card denial can turn into a courtroom problem far faster than it used to. Immigration lawyers, myself included, increasingly believe these notices to appear are being generated almost automatically, very shortly after a denial goes out. I can't prove that with certainty, but the timing lines up too consistently to ignore. So my old default advice, just refile the I-485 immediately and fix whatever went wrong, isn't automatically the safe move anymore. If a notice to appear is coming regardless, refiling might just mean paying the fees twice and still ending up in front of a judge. That's why the decision between refiling, reopening, or reconsidering matters more this year than it has in a long time. So let's talk about when a motion to reopen actually makes sense. A motion to reopen is built for one specific situation: new evidence or a changed circumstance that genuinely did not exist and could not have been submitted before the decision was made. Here's the case I'm working on right now. My client had been charged with theft years ago, but it was mistaken identity, and the charge was eventually dismissed after the court reviewed it. Before that dismissal came through, USCIS sent a request for evidence, essentially saying, "Our records show a criminal charge. Send us the final court disposition showing how it was resolved." We didn't have it yet. Worse, USCIS escalated to a notice of intent to deny and gave us only 30 days to respond. We submitted everything we had, but the local municipal court simply didn't have hearing dates available in time. The deadline passed while we were still waiting on the court system itself to move. A few days after that window closed, my client finally got me the certificate of disposition, showing the case had been fully dismissed. I sent it to USCIS immediately. That was January 2026. 6 months later in July, the denial came back. Missed the deadline by a few days, doesn't qualify for an exception, application denied. My first instinct was to just refile the I-485 on the spot, but I stopped myself because under this year's tougher enforcement climate, Refiling could realistically mean walking straight into a notice to appear anyway, and then we'd have spent the filing fee just to end up defending him in removal proceedings regardless. The good news is that this case is absolutely winnable in court if it comes to that, because he has an approved I-130 petition through marriage to a U.S. citizen, which makes him fully eligible for adjustment of status on the merits. But then I looked at the actual facts again and realized something important. We now have a piece of evidence, the disposition certificate, that genuinely did not exist in a form we could submit before that deadline expired, and that is precisely what a motion to reopen exists for. It's worth knowing, too, that under USCIS's own appeals procedures, there's some built-in flexibility here that doesn't exist for every type of motion. Officers can excuse a late motion to reopen if you can show the delay was reasonable and outside your control, but there's no equivalent discretion to excuse a late motion to reconsider, and that distinction alone can decide which form is worth filing. Now let's talk about the other lane, a motion to reconsider. This one isn't about new evidence. It's about arguing that USCIS got the law wrong on the facts that were already in front of them. Here's a scenario I see more than people expect. If someone is already in removal proceedings, jurisdiction over their I-485 normally shifts entirely to the immigration judge, not USCIS. There's one narrow exception. If the notice to appear checks the box classifying the person as an arriving alien, that box is one of three options at the top of the physical notice to appear. And if DHS checked that one, USCIS, not the immigration court, keeps exclusive jurisdiction over the green card application. I have personally watched USCIS officers get this wrong in interviews, telling arriving alien applicants, "We don't have jurisdiction, we're administratively closing this," when the law says the opposite. That is a mistake, and it's exactly the kind of legal error a motion to reconsider is designed to fix. And to be clear, you're allowed to combine both. Form I-290B lets you file a motion to reopen and a motion to reconsider on the same submission, if your case genuinely has both a factual and a legal problem. That form currently carries an $800 filing fee, and that hasn't changed. It's also not fast. Motions like this typically take around 6 months to get a decision, sometimes longer if the case is complicated. So this isn't a shortcut, it's a strategic choice. And here's the part I want to be honest with you about. In my experience, most people who try to handle this on their own end up filing a motion when they don't actually qualify for either one, meaning USCIS's original decision was correct given the facts they had. And in that situation, no amount of paperwork changes the outcome. You need to be looking at completely different options instead, whether that's a fresh filing done correctly, consular processing, or preparing a defense in immigration court from the start. If any of this applies to your situation, a recent denial, a missed deadline that wasn't your fault, or a notice to appear that seems to have the jurisdiction wrong, don't guess at which box to check on that form. The 30-day or 33-day window is unforgiving, and USCIS enforces it strictly, almost without exception. If you found this useful, do me a real favor and hit like on this video. It's the single biggest signal that tells me which topics you actually want more of. And if there's a specific immigration issue you're dealing with right now, drop it in the comments below. I read every one, and if it's something I can speak to accurately, I'll turn it into a future video. If you're new here, subscribe so you're getting real-time breakdowns of these policy changes as they happen, straight from an immigration lawyer's perspective, not a headline. Thanks so much for watching, and I'll see you in the next one.